Cell phones are covered by the Fourth Amendment. So that applies to cell phone tracking. And what that means is the Supreme Court handed down a landmark opinion today in the Carpenter versus United States ruling 5-4 that the Fourth Amendment protects cell phone location information in an opinion by Chief Justice Roberts. The court recognized that location information collected by cell providers like Sprint, AT&T, and Verizon creates a detailed chronicle of a person's physical presence compiled every day, every moment over years. As a result, police must now get a warrant before obtaining this data. And this is a major victory. Cell phones are essential to modern life, but the way that cell phones operate, by constantly connecting to cell towers to exchange data, make it possible for cell providers to collect information on everywhere that each phone, and by extension each phone's owner, has been for years in the past. As the court noted, not only does access to this kind of information allow the government to achieve near-perfect surveillance, as if it had attached an ankle monitor to the phone's user, but because phone companies collect it for every device, the police need not even know in advance whether they want to follow a particular individual or when. For years, the government has argued that the sensitive nature of the data doesn't matter. The mere fact that it's collected by phone companies make it automatically devoid of constitutional protection. This argument is based on an outdated legal principle called the third-party doctrine, which was developed by the Supreme Court in two main cases from the 1970s involving records of phone calls and bank transactions. Courts around the country had long been deeply divided on whether the third-party doctrine should apply to cell phone location information or whether the invasiveness of the tracking it enables should require a more privacy-protective rule. There is a world of difference between the limited types of personal information addressed in prior Supreme Court cases and the exhaustive chronicle of location information casually collected by wireless carriers today. So with that being said, it has said that the government's reliance on the third-party doctrine has been rejected, writing that there is a world of difference between the limited types of personal information addressed in prior Supreme Court cases and the exhaustive chronicle of location information casually collected by wireless carriers. The court also explained that cell phone location information is not truly shared, as one normally understands the term, particularly because a phone logs a cell site record by dint of its operation without any affirmative act on the part of the user beyond powering up. So, with that being said, it is illegal. It's a violation of your Fourth Amendment right and a violation of my Fourth Amendment right for any of you to be illegally surveilling me. I didn't give you permission, so get the fuck out of here. And so, I also ask, what do you know about cell phone usage or being able to have a cell phone in the courthouse? Mind you, I say courthouse. I didn't say the courtroom. Well, proof of fact is that you cannot have a recording device, a cell phone, or anything of interruption in a courtroom. But there's nothing saying that you cannot take your phone or electronic device into the courthouse lobby. Therefore, Federal Court, Burlington, Vermont, I ask you again publicly and nationally, as I sit here in Washington, D.C., Burlington Federal Court, security, marshals, and all, T.J. Donovan and Jeffrey Eaton, who stole my phone and who got into my personal identification?